For the very first time in the electoral bond case, today we heard the views of corporate India. Never before have they appeared or argued in the Supreme Court on their names being disclosed as political donors. So what do they want? Let's take a look. Now, India's leading industry bodies, the CII, FICCI and ASSOCHAM today appeared before the top court and for the first time openly batted against disclosure of alphanumeric serial numbers of electoral bonds. They argued that they are comfortable with two separate lists of corporate donors and recipient parties, but they strongly opposed releasing serial number as that would link the two sets of information and disclose specific donations by corporates to a particular political party. So why the concern? Well, there are quite a few of them. The biggest concern, however, for India Inc. appears to be that of political vengeance and retribution. And they are not mincing words. The plea by ASSOCHAM, for instance, very clearly says that due to anonymity, many companies had picked bonds fearing consequences from political opponents. They argued that preserving privacy was critical in guarding against any adversity by parties to whom contributions were not made. The plea argues that information linking one company to a party can be hugely damaging. Concern number two, retrospectivity. Industry bodies have argued that bond scheme allowed for anonymity. They argued that the Supreme Court order has retrospectively applied a higher standard of disclosure. This, India Inc. argues, is against the principle of certainty and predictability. They claim that this undermines the rule of law. Concern number three, no hearing. The industry bodies claim before the top court that not once were they heard. They claimed that the Supreme Court had passed its judgment without hearing concerns of corporate donors. Their applications have argued that principles of fair hearing and natural justice should be respected. And finally, concern number four, statutory rights. Corporates have sought to argue that the law gave the assurance of confidentiality. They have argued that there was a legitimate expectation of confidentiality and that this formed the basis of their decisions to buy electoral bonds. This confidentiality, as per the industry bodies, was a statutory right. The Supreme Court, however, was not impressed with these arguments. The court observed that it had passed interim orders way back in April of 2019, that the interim orders had put to notice all stakeholders about the uncertainty over legality of electoral bonds. The whole world knew, the Supreme Court remarked today, and that corporates had looked to join the hearing only after the judgment. So for now, clear directions for the SBI to release the serial number of electoral bonds.
Make informed decisions with comprehensive analysis on the go.
Strengthen your portfolio with real-time market updates on the go. Create effective strategies with insightful expert opinions on the go.
Grow on the go with CNBC-TV18, now streaming live 24/7 on YouTube.
For more news and updates, all you need to do is follow CNBC TV18 on all of our digital platforms.